Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Timothy Shader, decided November 26, 2024. Troutman, J. Defendant, previously determined to be a Level 3 risk under the Sex Offender Registration Act, SORA, Correction Law Section 168 et seq. Commenced this proceeding pursuant to Correction Law Section 168(0). 2. Seeking an order modifying his risk level classification. We hold that County Court did not abuse its discretion in modifying defendant's Level 3 classification to Level 2 but denying further modification to Level 1. In 1977, defendant, age 19, entered the home of a woman to whom he was a complete stranger at approximately 3 a.m. after the woman attempted to defend herself by striking him in the head with a heavy object. Defendant overpowered her, rendered her unconscious using an ether or chloroform-soaked rag, and tied her up. He then raped and sodomized her. At the time of those crimes, defendant already had an escalating history of sex offenses. His first instance of sexual misbehavior occurred in 1968 when he reportedly exposed himself in school, although that incident does not appear to have led to legal proceedings. Sometime thereafter, he was adjudicated a juvenile delinquent and placed on 1 year of probation for conduct that, if committed by an adult, would constitute the crime of sexual abuse in the first degree. Penal Law Section 130.65. Still later, in 1973, defendant forced a girl he was dating into sex, and he was charged with rape in the first degree. Section 130.35, convicted on a reduced charge of sexual misconduct. Section 130.20, and again placed on probation. In 1974, at around midnight, he followed 2 women who were leaving a bar and attempted to grab them. After one escaped, he took the other to a barn where he forced her to disrobe, took off his own clothes, lay atop her, fondled her, and stated his intent to rape her, before he was interrupted by an approaching vehicle. Defendant was adjudicated a youthful offender following a conviction of attempted rape in the first degree. Section 110.00, Section 130.35, and sentenced to prison. He then committed his 1977 crimes 1 month after his release, while he was still on parole for the attempted rape. Defendant was convicted upon a jury verdict of, inter alia, rape in the first degree, sodomy in the first degree, former Section 130.50, and burglary in the second degree, Section 140.25, and the court sentenced him to a prison term of 8 1/3 to 30 years. Defendant served 21 years in prison. At first, he denied responsibility for his criminal conduct and refused to participate in sex offender treatment, but he eventually took responsibility and enrolled in treatment, which he completed. Defendant was released to parole in 1998, and the sentencing court determined him to be a Level 3 risk pursuant to SORA. The risk assessment of the Board of Examiners of Sex Offenders, Board, assessed him a total of 125 points based on the nature of his offense and his criminal history, which alone put defendant above the 110-point threshold required to classify him as a presumptive Level 3 risk. In 2003, while still on parole, defendant was convicted of 2 misdemeanors: attempted auto-stripping and attempted possession of burglary tools. He has no other convictions since his 1998 release. In 2021, defendant petitioned under Correction Law Section 168(0)(2) to modify his risk level classification to Level 1. Defendant argued that he posed a low risk of reoffense based on his engagement in one-on-one outpatient sex offender treatment from 1998 to 2008, his steady full-time employment, including his current job, which he had held for 17 years, his stable and loving relationship with his wife, whom he met in 2008, his role as stepfather to his wife's daughter, and his age of 66 years. Defendant also noted that he had fully complied with his SORA obligations since his release 23 years earlier and, aside from his 2003 misdemeanor conviction, had not reoffended. He submitted letters of support from his counselor, wife, and stepdaughter. In addition, he submitted the report of an expert psychologist who examined him and concluded that his risk of reoffense was low, and that requiring him to register at risk level 3 was no longer necessary for purposes of public safety. At the court's request, see Correction Law Section 168.0.4, the board submitted an updated recommendation, stating that it would not oppose defendant's request for a modification to level 1. The people opposed any modification of defendant's risk level. Although the people did not challenge defendant's extensive evidence of rehabilitation, they argued that modification was inappropriate based on, inter alia, the seriousness of his crimes and his criminal record. County Court granted the petition in part and modified defendant's risk level to level 2. The court noted that the board did not recommend modification to risk level 1. The board just didn't oppose it. Nevertheless, considering the submissions by the board, defendant, and the people, the court concluded that defendant proved by clear and convincing evidence that he was less likely to reoffend than he was when he was released from prison in 1998, and classified as a level 3 risk. At the same time, however, the court found that defendant failed to prove by clear and convincing evidence that he was so less likely to offend as to warrant a modification to risk level 1. Specifically, the court found that the seriousness of his 1977 crimes, wherein defendant committed a burglary of the victim's home and assaulted and raped her, outweighed the fact that defendant had not committed any sex offenses since his 1998 release. The court also considered defendant's significant history of sex offenses preceding his 1977 crimes, the commission of the 1977 crime only 1 month after his release to parole, and his 2003 post-release misdemeanor conviction, also while on parole, of attempted auto-stripping and attempted possession of burglary tools. Based on all of the facts and circumstances, the court concluded that a risk level 2 classification was appropriate. The appellate division held that there was no abuse of discretion and affirmed, and we granted defendant leave to appeal. In making the initial risk level determination pursuant to SORA, the court must assess the offender's risk to the public safety in accordance with guidelines adopted by the board that are based upon statutory factors, including the nature of the offense and any prior offenses. See Correction Law Section 168L. 5. Section 168N. 2. Following the initial risk level determination, registered sex offenders may petition annually to modify their risk level classifications. See Section 168.0.2. The offender's petition must set forth the level of notification sought, together with the reasons for seeking such determination. The legislature has assigned to the offender the burden of proving, by clear and convincing evidence, the facts supporting the offender's requested modification. On a petition for modification, as with the initial risk level determination, the nature of a defendant's crime is a relevant, important factor to be considered by the hearing court. People v. Davis. See People v. Charles. As is the defendant's criminal history. See People v. Lewis. The analysis must not end there, however, because the court must request an updated recommendation from the board and consider that recommendation and any other relevant materials and evidence submitted by the parties. Correction Law Section 168.0.4. Including any evidence of rehabilitation or other changed circumstances. The court must undertake a thorough analysis of a defendant's likelihood of reoffending and the danger the defendant poses to the community in which he or she resides, in the event of a reduced risk level classification. Davis. The relevant inquiry is whether the petitioner has proved by clear and convincing evidence that conditions have changed subsequent to the initial risk level classification, so as to warrant a modification thereof. People v. Lashway. See People v. Clark. People v. Bentley. Where the hearing court's findings, expressly made under the proper evidentiary standard, are affirmed by the appellate division, this court's review is limited to whether the decisions below are affected by an error of law or are otherwise not supported by the record. People v. Lashway. Here, we conclude that the court did not abuse its discretion in granting defendant's petition in part and modifying his risk level classification from level 3 to level 2 but denying further modification to level 1. See Charles. The court properly considered the board's and defendant's submissions, including the undisputed evidence of rehabilitation, in concluding that defendant proved by clear and convincing evidence that he was less likely to reoffend than he was at the time of his 1998 release. The court also properly considered the countervailing evidence in concluding that defendant failed to prove by clear and convincing evidence that a Level 1 classification was appropriate. That evidence included the nature of the underlying offense, which defendant committed while on parole for a prior sex crime, defendant's prior offenses, and defendant's 2003 misdemeanor conviction of crimes committed while on parole for the underlying offense, for which he received a parole violation. Although the misdemeanors appear to have involved no violence or sexual component, we cannot conclude that the court's consideration of that factor, along with all the other factors, constitutes an abuse of discretion as a matter of law. Our dissenting colleague's approach to modification proceedings would insulate that process from the primary goal of SORA, namely, to protect the public from the danger of recidivism posed by sex offenders, to assist the criminal justice system to identify, investigate, apprehend and prosecute sex offenders, and to comply with the Federal Crime Control Act, People v. Boone, quoting People v. Stevens. Put another way, the statute aims to protect members of the community, particularly their children, by notifying them of the presence of individuals in their midst who may present a danger, and to enhance law enforcement authorities' ability to investigate and prosecute future sex crimes, quoting Doe v. Pataki. These overarching goals are as relevant to a modification proceeding as they are to an initial risk level classification. Our dissenting colleague's interpretation of the statute would, if adopted by this court, expose the public to the risk the statute was enacted to protect against, by limiting, as a matter of law, the types of convictions the SORA court could consider in determining whether to lower a defendant's risk level. The dissent's analogy to People v. Brown is inapt because the defendant in that case never committed an offense that was sexual in nature. Here, in stark contrast, defendant committed a serious sexual assault and was responsible for a string of sex offenses, and the question is whether his more recent criminal conduct bears on the risk of his committing future sex offenses. Under the dissent's proposed rule, the SORA court would be prohibited from considering that defendant violated the law and his parole when he was caught with burglary tools after being convicted of raping a young woman during the course of a burglary also committed while defendant was on parole. We decline to endorse that untenable result. The dissent altogether ignores the burden of proof by speculating about the specific kinds of burglary tools that may have been in defendant's possession and the manner in which he used those tools. The dissent's approach is tantamount to requiring the lower courts, contrary to the clear directive of the correction law, to construe the record in the light most favorable to the defendant. The error is most clearly demonstrated by the dissent's own citation to Correction Law Section 168(0)(3), which governs petitions filed by the people for an upward modification of an offender's risk level. In those circumstances, the people must show that the defendant's risk of reoffense has increased since the initial risk level adjudication, and the proof must establish a heightened threat to the community that the defendant will commit another sex offense. Thus, unlike the provision that governs here, Section 168(0)(3) assigns to the people the burden of demonstrating entitlement to such a modification by clear and convincing evidence. In short, it was not the people's burden on this defendant's petition to show that his post-release crimes were sexually motivated. Next, according to the dissent, the SORA court erred by relying on the prior sex offenses committed by the defendant without engaging with what has changed since. As detailed above, this is simply a misreading of the record. As a general matter, the dissent's approach again misapprehends the nature of the modification proceeding. The original risk level designation is presumed to apply, and the defendant has the burden of demonstrating by clear and convincing evidence that a modification of that risk level is warranted. See Correction Law Section 168(0)(2). The SORA court would be remiss if it did not give weight to the serious, indeed heinous, nature of defendant's crimes. The dissent's flawed premise that the statute guarantees to every Level 2 and Level 3 sex offender the ability to obtain a modification to Level 1 is unsupported by the statute's text and misapprehends SORA's legislative purpose, Brown, which is to further the protection of the community against people who have shown themselves capable of committing sex crimes. The legislature has rejected that premise by providing that certain sex offenders, like Level 3 sex offenders, must register for life. Correction Law Section 168H, 2. Modification proceedings offer those defendants an opportunity to prove to a magistrate that the original assessment should no longer apply. They do not guarantee relief from this obligation. Rather than committing the parade of errors listed by the dissent, the SORA court, under the proper framework, considered all the relevant materials and evidence, and made an informed judgment about which risk level designation was appropriate. The court's conclusion that defendant demonstrated entitlement to some relief from the more stringent requirements of a risk level 3 designation was an appropriate exercise of the SORA court's discretion in keeping with its statutory responsibility to protect the public. Finally, contrary to the dissent's suggestion, appellate review of modification proceedings is robust. While the statute broadly confers upon the SORA court the discretion to grant or deny a modification petition without deference to the decision of the board, Lashway, the appellate division has the power to exercise its own discretion in an appropriate case and grant a defendant's petition even absent an abuse of discretion by the SORA court. C. Davis, modifying risk level classification to level 1 on the facts and in the interest of justice. See generally People v. Ch. Although we do not conclude that the court abused its discretion in denying defendant youthful offender status, we choose to exercise our discretion in the interest of justice to determine that defendant is a youthful offender, and we review for legal error or lack of record support. See Lashway. We do not blame our colleagues or the lower courts for failing to do what we might have done in the first instance. Mr. Shader cannot do better, we can. Our decision does not preclude defendant from petitioning for a modification to risk level 1 based upon updated facts. See Correction Law Section 168.0. 2. Or for relief from his duty to register after 30 years of SORA registration. Section 168.0. 1. Accordingly, the order of the appellate division should be affirmed, without costs. Order affirmed, without costs. Opinion by Judge Troutman. Judges Garcia, Singas and Canataro concur. Chief Judge Wilson dissents in an opinion, in which Judges Rivera and Halligan concur. Decided November 26, 2024.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law